Hi, I'm Michael Santos with PrisonProfessor.com, and I'm offering this 10-point plan for defendants who anticipate that they may face a sentencing hearing in federal court. Now, I spoke with 4 federal judges at a legal symposium that UC Hastings sponsored. The judges offered a lot of insight that I was convinced that defendants who are at the earliest stages of a criminal proceeding, whether it's a criminal information, an indictment, or even if the individual has just been found guilty, that individual would find this information that I learned from the 4 federal judges very helpful. So I wanted to share it with people. So the first lesson that I want to talk about, or the first takeaway, is that judges find sentencing to be the most difficult aspect of their responsibilities. I heard from 5 different judges who all expressed that same sentiment. They said that it was incredibly difficult to determine an appropriate sentence on an individual. So what they did is they relied upon the sentencing guidelines as a starting point. But since the Supreme Court handed down its decision in Booker, making the guidelines advisory rather than mandatory, the judges have considerably more discretion than they had before. Still, the only information a judge has about the defendant is what the government produced, whether it's the prosecutor or the probation officer, which is really just an extension of the prosecutor's version of events. Certainly, a defense attorney is going to offer information, but based on what the judges said, I am confident that a defendant should take upon himself the responsibility of helping ease the judge's challenge of sentencing by offering more insight about his own background, his experience, what he's been through, what led him to the decisions that he made. So the second point that I think that individuals would want to consider before sentencing is to prepare themselves better. Without a doubt, the defendant is going to have an attorney who works to prepare an effective sentencing memorandum. And that memorandum may be replete with legal citations that validate reasons why a judge can impose a low sentence, but the reality is the judge knows a lot of that already. I mean, he's been sitting on the bench, he's sentenced thousands of defendants during his career, or her career. So the defense attorney may make some very eloquent arguments, but from what I heard from those federal judges, I don't think that's enough. A judge is used to listening to defense attorneys. Even if a heinous defendant appears for sentencing, that defendant is going to have a defense attorney who argues for the lowest possible sentence. It's much more rare for a defendant to be able to stand up there and articulate in a concise manner why he is worthy of the lowest possible sentence. So I think that a defendant who prepares himself well for the sentencing hearing, understands everything that he can about the sentencing hearing, will certainly advance the possibilities for leniency. The third point for a defendant to consider is that he must speak sincerely. The judges with whom I spoke were quite clear on this point. They didn't want to encounter a defendant who was reading from a script that had been edited and polished, possibly by someone else. It doesn't matter how eloquent the defendant is. What matters is that he speaks sincerely. He should look the judge in the eye. He should stand erect. He should be able to express his remorse with a sense of deep meaning and feeling. And to the extent that he can convey that to the judge, he is going to, again, advance his possibility of receiving a more leniency during the sentencing. It's very important to remember that judges are on that bench for a long time. They can quickly assess perceptions of whether that individual is sincere or not. So I think it's really important for the individual to work on that and not just approach the sentencing hearing on that day without a plan. And that leads me to the fourth point, which is the defendant must be authentic. Judges at that conference told me that they wanted to see a defendant who was the real deal, somebody who was truly expressing who he was, and it should be expressed more than just in words. They were less inclined to grant leniency to a defendant if they perceived the defendant was trying to pull something over or present a situational type of saying he's sorry or saying he's remorseful. With high recidivism rates being what they are, it's easy to understand why judges are so cynical of defendants who stand before them at sentencing. So it's important for a defendant to understand that and have a plan on how he is going to overcome it. The fifth point that the judges made was that they become very cynical about a defendant who stands up before them and talks about finding religion. They perceive such statements as being situational. The individual, that from their perspective, if an individual gets up there and talks about God and their newfound faith, the judge is really thinking this is somebody who hasn't thought seriously about his crime or his current predicament. So although I'm not making any judgment call on the power of spirituality or religion at the sentencing hearing, it's best to keep those statements private rather than invoking them for the judge to consider. The sixth point that I'd like to suggest or recommend is that the defendant show rather than talk about remorse. This is a big one. Every defendant who speaks before the court is going to speak about being sorry or his remorse, how he wishes that he didn't do it. But that all harkens back to that old fable of the boy who cried wolf. There's a lot of people who talk about being sorry, or a lot of people who talk about being remorseful, but it doesn't necessarily make it true. And as a consequence of the judge's experience of having sentenced thousands of people with 70% recidivism rates, it's more easy to understand why the judge is reluctant to believe that. So if a defendant knows that, the defendant can take action and create a scenario that will demonstrate his remorse. And that's the key takeaway here, is to be able to show the individual is remorseful. Seventh point, don't ask for forgiveness. Judges say that when a defendant asks for forgiveness, it's just a wasted breath. The reality is a judge cannot grant forgiveness. Only the victim can, or perhaps only God can. What the judge can grant is mercy or leniency at sentencing. And if the individual is looking for leniency at sentencing, he should then offer reasons. Every defendant coming before them, this is our eighth point, every defendant coming before him should prepare himself to encounter a judge who is very cynical. And they should put themselves in the judge's chair, understanding, well, what has this judge heard for the last decade? How many defensive attorneys have been asking for a lower sentence? How many defendants have asked for a lower sentence? It's much more important for the defendant to be able to provide a compelling case that demonstrates why he is worthy of the lowest possible sentence. That's one of the areas that I work with defendants on based on my experience of serving 26 years in prison and working with thousands of people who've gone through the system. It's crucial that the defendant offers some compelling reasons that argue for the lowest possible sentence. In a first-person narrative, of course the defense attorney is going to do it, but the defendant must prepare himself to do it as well. Number 9, don't shift blame. This is perhaps the worst thing that a defendant can do, and yet it's one of the most common things that defendants do at the sentencing hearing, is they want to shift blame or shift responsibility, or say, I only pleaded guilty because I didn't want to get sentenced to a longer term. It's very important to recognize that does not advance the case for leniency. A defendant who wants to receive leniency at sentencing must think strategically, deliberately, focused on how he is going to make the most compelling case, the most persuasive case on why he is worthy of the lowest possible sentence. And to do that, he needs to articulate a plan. That plan should cover all aspects of the defendant's life in a first-person narrative. I recommend that plan should be written, and it should be comprehensive. It should be well edited, well thought out, because that plan alone is going to be the heft that a judge may or may not read, but just holding it in the judge's hand can have a significant impact. And then the defendant must be able to stand before the judge at that hearing and offer a very succinct reason on why he's worthy of the lowest sentence. That's what I learned.
Hi, I'm Michael Santos.
Oh my God, what happened there? Sorry about that. I don't know why. Oh well. Hey, I'm trying to finish this with technology, but it's a bit of a challenge for me. After all, I did 26 years in prison, doing the best that I can. Anyway, I'm Michael Santos with PrisonProfessor.com. Wanted to share this brief tutorial on sentencing with each of you. I hope you find value in it. If there's any way that I can contribute to your sentencing hearing, your preparation for sentencing, your sentence mitigation strategy, contact me. I've got a wealth of experience, and I know that I can help you. Thank you very much for your time.